Good afternoon. My name is Professor Gad Barzilai. We are again on a virtual conference of Minerva, or a workshop. And today we have a special guest, Advocate Joel Slawotsky. Joel is a well-known attorney and litigator in the United States. He was clerking for Justice Thomas in the United States, and now he's a visiting professor in the IDC, University of Reichman. Now, usually when we are talking about effects and trajectories and ramifications of COVID-19 pandemic, we are usually almost automatically are talking about international law, public law, and administrative law. But today, Joel will take us into, in a way, a different direction, or a complementary direction, which is a direction of private law. And he will talk for the next about 30 minutes about the effects of COVID-19 and other type of national crisis on obligations in private law over contracts, which is also, by the way, an issue which has been recently debated in the Israeli Supreme Court, and soon enough will become a prominent issue in Israeli private law as well, on the backdrop of the pandemic. So, Joel, you are very welcome, and please begin your lecture. Thanks very much for coming.
Thank you very much, Gadi. Thank you. And for anybody, since we're going to be talking a little bit about Chinese corporate debt, let me just add in Chinese for anybody who views this later, Wahan Gao Sing Lai Dao Jeli, which means in English, I'm very happy to be here. It's an honor and a pleasure to be here. I think it's an interesting topic, and Gadi, especially for you, you are an expert in international politics and economics, and this topic basically engages in several of these topics, economics, politics, the U.S.-China hegemonic rivalry, and it also implicates law, contracts, and it also implicates international law, because it has to do with the essential security exception. I would also like to add that this paper has been accepted. It was accepted, and it's actually going to be published next month in January. There's already pre-publication in the Oxford University Press Journal of the Capital Markets Law Journal. So this is already going to be published, and most people here will probably have access to OUP publications, but if for some reason somebody in the future who's watching this and they want to obtain a copy, they're more than welcome to contact me, and I will, of course, send them a copy of the article if they wish to see it. So without further ado, let me give you the hypothetical overview of this presentation. We all know that there's a lot of debt in the world, and it's not just relegated to China. The United States federal deficit is basically the debt. The national debt is approaching, or approximately 30 trillion. China also has a lot of debt. The world is awash in debt, and at some point, the music will stop. It's a question of time before the next global financial crisis occurs, and clearly, this will implicate Chinese corporate debt, which has approximately, and I know there are different reports because nobody knows for sure, they're not as transparent, the reporting systems are not as transparent as, for example, in the United States, but there's well over $100 billion of Chinese offshore debt that is backed by what's called comfort letters. They do not contain an explicit guarantee. It would take me hours to go through this, and obviously it's in the article, but in sum and substance, for legal reasons, the onshore entities in China cannot guarantee offshore dollar debt. So it is backed by a comfort letter. And the overview of the presentation, it's a hypothetical because this has not happened yet, although I think that in the coming years it will happen. I think it's inevitable, but there's no guarantee it will, is that the debt will not be paid by some corporate borrower, and there will be a default, and investors will use or will look to the comfort letter to get payment. Where's the money? Eifo hakesef. Where is the money? And the hypothesis is that Chinese mainland courts, for a variety of reasons, may not enforce the comfort letter, and as a result, investors from overseas, if there's an applicable investment treaty, will go to arbitration and seek to recoup their losses. And the question will be well, the Chinese will defend and say, we did this because of essential security. What is essential security? So let us take a look at two overarching themes of the presentation. One, the next global financial crisis. As I said at the outset, to me at least, and people are free to disagree, I think it's inevitable that at some point there will be a financial crisis. And the question to me is, when, not if. And there's a lot of debt, and it implicates the issue of comfort letters because we live in a low interest rate environment globally. We live in a zero interest rate policy environment in many countries, and that leads to risk taking. People, investors, corporations will tend to take on more debt because it's so cheap, it is so inexpensive to borrow, and investors will also seek to gain a yield, and if there's a high risk, they're willing to take that risk in order to gain a yield. Now, when it comes to the essential security exception in international investment law, as Gandhi, and many others here know, the classical interpretation, the classical understanding of national security has been territorial integrity, defense of the borders. And actually I wrote an article which was published about 6 months ago in the Chinese Journal of International Law that discusses the reconceptualization of national security in international economic law. There are really three factors that are militating towards a reconceptualization of security. One, and we're going to discuss this a little bit later in a few minutes, we'll discuss it and I'll give you some examples, is transformative emerging technology, artificial intelligence, CBDC, central bank digital currencies. You no longer need to physically invade another country in order to degrade that other country. You can use emerging technology to do a variety of nefarious interests that will erode the security of that other country. Two, we live in an era of a hegemonic rivalry between the current hegemon, the United States, and an ascendant power, China. And there is a lot that goes on there. I mean, we see now that the United States claims that there are human rights violations in Xinjiang, and that these allegations, according to the United States, basically it poses they claim it poses a national security risk to the United States, which is a very, very substantial departure from the historic conceptualization of national security. And then, which we will discuss again in a few minutes. I'll discuss it in a little more detail. And third is the understanding, and I think this is very, very relevant to the Minerva Center, there is a growing perception that national security does not only mean, quote unquote, military defense. It also means defending the national bastion with respect to health, education, stability, avoidance of economic crisis, avoidance of poverty, and we live in an era of climate change and the COVID pandemic. Okay? Maybe that also should drive this reconceptualization. So let's take a quick look, and I won't spend too much time on the background, because I think particularly for the Minerva Center and other people that are interested, it's going to be more of the security exception and how it interacts with comfort letters. But I have to provide some background to the whole issue. Comfort letters are basically statements or assurances that the debt will be backed up. When I say backed up, what it means is that the onshore entity will ensure the liquidity or the solvency of the debtor, and that kind of gives some sort of plausible deniability. Let me just go back up. Plausible deniability to the one who's giving the comfort letter, but it induces the investor to give money. And there are growing indications of defaults in China. The rate of defaults are rising. The Huarong example, Huarong was a company that was set up to take into account or to clean up the corrupt privatization back about 15 to 20 years ago. And unfortunately, they kind of bit off more than they could chew, and they over-leveraged themselves, and Huarong got into a lot of trouble. Now, I think many of you may have heard about Evergrande, which is a giant real estate company in China. And again, they overstretched. There's a lot of leverage. There's a lot of debt there. I believe when it says here they have $300 billion in debt, I have no reason to dispute that. It's a lot of money. That's a serious chunk of change. And as you can see, their dollar bonds are dropping. They employ a lot of people. It's important because when we talk about good faith, and we talk about a little bit later, when we talk about paying back the debt, yet we need to keep in mind that companies such as Evergrande are very, very important to the Chinese economy. And this is just a bigger slide of the Evergrande bonds, and this is just a report from the New York Times about the fact that they're in serious trouble. Anyway, will the Chinese government bail out these borrowers? Will the Chinese government allow these borrowers to fail? Are they too big to fail, particularly ones that are state-linked? And this is a very, very important issue because the answers will have very, very substantial implications for China and markets across Asia. And there has been a core assumption or core tenet of investment in China that the Chinese government will back large borrowers. And maybe that's not going to happen any longer. Let us see it. So what happens? Hypothetical: Evergrande or some other company can't pay back it's the interest, or even the Karen, the principal is wiped out, or the interest. There's a problem, and the foreign investors are not paid. So the investors then file a claim. Depending upon the locus of dispute resolution, it could be many of them. The locus of resolution is Hong Kong. It doesn't matter for purposes of our discussion. The investors file a claim. They say that the comfort letters were provided to, and therefore they lent the money. But for the comfort letter, they would not have lent the money. By the way, comfort letters are not necessarily bad things or evil things. It doesn't mean that there's only nefarious motives. They are sometimes just done for regulatory purposes. Maybe they don't want to carry the debt on their books, et cetera, et cetera. But the bottom line is they are often very nebulously worded. There's plausible deniability, and there is absolutely no express guarantee when it comes to a comfort letter. These letters do not say that the onshore parent is going to pay the debt. The debt is not even often referenced. What happens is as I said, the onshore parent will basically say, we are going to make sure that the borrower stays solvent, or we will make best efforts at keeping the borrower solvent. There's no guarantee. There is no specific contract. So are the overseas foreign investors up the creek without a paddle? Are they the friars, right? Are they the suckers? Well, there is a possibility that they can recover, because there is a concept, as many of you know, of promissory estoppel. And promissory estoppel, which is very, very inextricably connected to good faith, basically says that the promissor, the entity that issued the comfort letter, has a duty to prevent the unfair, detrimental reliance on the part of the promisee. If the investor in good faith really thought that this was going to save them, that they really had the ultimate benefactor, then it's possible that promissory estoppel could be used in order to enforce the comfort letter. And there's a great article from in the American Journal of Comparative Law from Bernstein and Jacko, basically talking about how the contractual duty is kind of moving towards more of a tort-based duty. And this is something that, anybody who's been in law school over the last, 15 or 20 years is maybe even 25 years is well aware of, is that courts, particularly in the United States, but in other common law jurisdictions as well, have been more inclined, although it's not universal, have been more inclined to look at discussions, words, statements in a more holistic fashion. Just because it doesn't say this is a binding contract does not necessarily mean there is no binding contract. And it's interesting because some courts around, if you look at Australia and Britain and even the United States, they don't universally embrace promissory estoppel. And you will have courts that say there is no contract and we're not going to enforce it. There are cases that I list in the article. Again, if you're interested in it, I'm happy to show it to you, send it to you. But it is not universal. So now we come to international arbitration. I think this is the heart of what people at the Minerva Center will be very interested in. There's a variety of possibilities as to why foreign investors might ultimately need to or might go to international arbitration. And it doesn't really make it, a specific difference. But the bottom line is, it is possible. It is entirely possible that even, for example, you could have if you look at number 3 in particular, investors file an action in Hong Kong, and the Hong Kong court says, you know what, this is enforceable. We think that the investors are due their money. Here's your judgment. And the investors go to the mainland and say, okay, the assets of the letter issuer is here. We want to enforce the judgment. And even though there's a reciprocity agreement, there's an agreement between the mainland courts and the Hong Kong courts, the mainland courts could decline enforcement if enforcing the judgment is contrary to the social and public interests of the People's Republic of China. So there's a lot of discretion and there's a lot of leeway. And if that happens, obviously the investors can make a complaint and say, you know what, the actions of the courts in China deprived us of fair and equitable treatment and therefore violated the investment treaty. And China would defend and say, you know what, we had to do it. Our courts had to defend our national interests. And here's where we come to the essential security exception. What is the essential security exception in terms of crisis, emergency? Is there a justification? How will arbitrators evaluate the defense? What constitutes a legitimate threat to an essential security interest that would justify not enforcing a judgment or a failure to enforce a comfort letter. The question is, what is essential security? There is, as we discussed at the outset, I'll just briefly mention, the classic conceptualization is defense of territorial integrity. It is the defense against military attack. And that's surely still the case, but should the horizons of national security be expanded? Conceptualization of essential security, obviously post-World War II, GATT, and all of the investment agreements basically say, again, it's in the article, and it would take hours, as you all know, to go through this, but basically, in very, very brief terms, even up till today, the conceptualization of security still remains basically defense-oriented. The Indian government had annulled a couple of contracts, actually went to arbitration very recently, relatively recently, and the arbitrators basically said, yes, for military and paramilitary interests, the Indian government was justified. It comes within the exception of essential security, but for other needs, such as railroads, utilities, communications, that's not essential security. So, are arbitrators going to continue with that? It's possible, but I think that there is going to be increasingly a realization that limitation of the security exception, that understanding of national security is going to have to be moved a bit. We have emerging technology threats that are increasingly virtual. We've got this hegemonic rivalry, which is very, very important. And we also have a growing belief that essential security is interconnected with human security. It's kind of like a spin-off of ESG in corporate governance. Even in the home of free market capitalism, Delaware, former Chief Justice Leo Strine, he authored the Marchand ruling. And in Marchand, they enhanced the duty on directors for monitoring. And this is a movement even within, I'm not even discussing the Business Roundtable, but this is the Delaware Supreme Court basically saying that Delaware directors have this duty towards, or this more societal duty to protect society. So let's quickly look through each one of these. Emerging technologies, which is one of the factors militating towards a reconceptualization. Take a look at, for example, I'll just take one to shorten it, central bank digital currencies. Former U.S. Treasury Secretary Mnuchin admitted that U.S. dollar sanctions are a replacement for war. This is not speculation. It's not, conspiracy talk. It's obviously, it's a fact. It's admitted that the United States uses sanctions because the U.S. dollar is so central to global finance. Sanctions are a replacement for war. Now, if you can degrade that, if the Chinese, who are leaders in digitalization, if they can successfully introduce, for example, a digital yuan and wean the global financial system off of the US dollar, that sure is a threat to U.S. national security from the U.S.'s viewpoint. Obviously, we're not here to blame or criticize. There was a song, Tears for Fears, everybody wants to rule the world. Every country wants to do it. If the United States can do it, they do it. If China can do it, they'll do it. But right now, the U.S. has that ability. The U.S. has that power, and China would like to, have that power, or at least diminish and erode the power of the United States to impose sanctions. And again, no shots are fired. The jet fighters are not flying. The engines of the tanks are not revving up. But you can attack American national security if you can lower the importance of the U.S. dollar. You also have now the U.S. Hegemonic Contest. And think about it. This is far beyond the original conceptualization of national security, delisting of Chinese shares, WeChat bans, WhatsApp bans. And again, China's also expanding the notion of national security. Is certainly not just the United States. China has blocked Tesla cars from government and PLA employees because they're afraid that data is going to be given over to Washington. So both powers, both superpowers, are expanding notions of security far beyond, way beyond the conceptualization of military attack or defense. And here's just a couple examples from last month. The U.S.-China Security Commission, the report to Congress: China's digital renminbi, digital yuan, does not present an immediate challenge, but in the long term, it could undermine the status. And look at the second one. This is, I'm not saying it's shocking, but it's a very, very sharp distinction from the classic conceptualization. China's tight integration with global financial markets poses distinct risks to U.S. investors and national security risks to the United States. So even China's integration with international capital markets is viewed as a national security threat. Again, far beyond the traditional understanding of national security. And then we have the broadening notions of stability and health as bulwarks of security. It's kind of like a spin-off of ESG and corporate governance, this growing perception that health and safety is important, avoiding economic crisis is important, avoiding poverty is important, this idea of human security. I'm timing myself, so I see I still have about another 5 to 7 minutes. There is an increasing recognition that states need to defend a more broad-minded understanding of security, not limited solely to physical defense. Human security recognizes the interlinkages between peace, development, and human rights. I think it's inevitable, myself, that arbitrators are going to start to have a greater empathy for realizing that security is not only military defense. It obviously is, it always will be, but there are other important aspects of national security. So the question, and we're going to put this together with comfort letters, you'll see this within the next few minutes, the question of whether defending human security is a legitimate fit, I think, is going to become more important. And the link between crisis and threats are manifestly clear, to me at least. Of course, people can disagree. When we talk about climate change, poverty alleviation, sustainability, I think that arbitrators will start moving towards that. And it's going to be very interesting whether that will prove to be sufficient excuse for the invocation of essential security. Of course, it's not simple. It's not a simple question. China does, in fact, possess the second largest economy in the world. Actually, their GDP on a PPP basis, a purchasing power parity basis, is actually number one already. But even nominal GDP, they're second to the United States, and they're closing the gap. I think that there's estimates that it will happen within the next 7 or 8 years, maybe a decade. Of course, if current trends continue, anything can happen. People thought Japan was going to take over in the 1980s. It didn't. But China is on track, if current trends continue, to become number one, even in nominal GDP. So they're not poor. And the question is, well, what about financial contagion and upheaval? Is that sufficient to justify the invocation of the security defense? Recall, I showed you Evergrande. Many, many employees. It's a very important part of the economy. What would happen if people's real estate values, housing values plummeted because Evergrande went bankrupt? That would cause a lot of instability, and which is very important in particular in China. It's important in all countries, but in particular, it's a culture that adores stability, and maybe that is a sufficient threat to them. I don't know. But it's also a very slippery slope. It's not simple at all. First of all, the security exception can swallow the rule. Are all data transfer points bona fide security threats? Anything that's connected to the internet, is that a national security threat because data? Are TikTok videos a security threat? I don't know. Maybe, maybe not. And if you look at, for example, Xinjiang, it's a slippery slope. The United States is saying that the alleged international law violations, for example, the forced labor violations in Xinjiang, constitute a national security threat to the United States. Well, China could turn it around and say, well, wait a second, what about your own internal house, which they've done? I mean, you've got a lot of minorities in prisons. Well, that's a national security threat to us. I mean, it sounds a little bit far-fetched. It certainly is very, very far removed from the traditional conceptualization of national security. When the United States says we will not allow U.S. persons to invest in companies that are involved in facial recognition in Xinjiang because of national security, again, it's a slippery slope, because does that also apply to internal policing in Xinjiang? What if China says we're going to enforce the family planning or the one-child policy, which they're doing, and the United States says, well, that's a national security threat, it's a violation of international, it's human rights. When you link human rights to national security, where do you draw the line? It's kind of, it's a slippery slope. Second, how do you measure economic crisis? How do you measure health? Vaccinations, is everybody supposed to be vaccinated, or do people have the right to say, I need to have more information? We all know, I mean, this is common knowledge, that there are many people against the mRNA vaccinations. One of the things, and some of it is obviously crazy conspiracy stuff. On the other hand, there are voices that have legitimate questions, and they're banned from Twitter and other social media. Well, don't people have the right to know everything? You don't want to hear just one side of the story to make an educated decision for yourself. You want to have as much information as possible. Clearly, we don't want to hear nonsense, and we don't want to hear that, people are being tracked and all that kind of stuff. But on the other hand, if there are problems, if there's damage to the immune system, I'm not saying there is, but there are people who say that there are problems, going to the immune system from mRNA. Well, I'd like to hear what they say. Maybe they're crazy. Maybe it's wrong. Maybe they've got a valid point. It's a slippery slope. Once you start to censor, where do you draw the line? And the third is security. National security can clearly be a cover for nefarious motives. You can obviously just say, well, national security, you just want to degrade the adversary. It doesn't mean that it's really legitimate. So I know I'm getting close, so let me try to, we're not that far off. I think I've got another 5 or 6 slides. I'll try to move it very quickly. While the precise contours of national security, the security exception, are unresolved, everybody will agree that you have to demonstrate good faith. Good faith is essential in order to invoke it. And should the tribunal find the exception improperly invoked, the panel is going to have to examine whether the comfort letter can be enforced. The role of good faith is essential. It's essential not just in terms of the international arbitration, it's also essential in terms of promissory estoppel. So good faith is really important, whether it's going to be playing a role in domestic courts or whether it's going to be in international arbitration. This is a listing of the Lasalle factors. Lasalle was a decision in the Southern District of New York that spoke about the wording of a comfort letter. And they actually said that it was not enforceable because I think it was Citigroup was a sophisticated party and they should have known better. But you have to look at the letter in a holistic way, whether the creditor was reasonable in relying upon the letter, whether the extent of understandings between the parties, the previous history, transactions, and relationships, and the sophistication. I think you might remember the subprime meltdown, it's on YouTube. There's a wonderful cross-examination of Goldman Sachs from Senator Carl Levin, and he basically got Goldman Sachs to admit that they knew that, I think it was Timberwolf collateralized debt obligations were garbage. I won't use the word, but hara, okay? They were garbage, and they were selling it to other customers. They knew that it was bad, but they were selling it to their clients. They wanted to unload it. So they were sophisticated, and the question is, when you're dealing with debt, maybe some of the people buying the debt are sophisticated. Maybe they know that the debt won't be repaid, or that there's a danger that it won't be repaid. Maybe, and it's a factor. That's a lack of good faith reliance, which would take away the argument for promissory estoppel. And last but not least, Chinese political, economic governance, moral hazards, and good faith. China has a very different political, economic governance system than most countries in the West, clearly the United States. In China, economic interests serve the political interests. Again, we're not criticizing it. We're not saying it's good. We're not saying it's bad. But that's the fact. And that raises the potential or the questioning of judicial independence. What happens if a mainland court says, we're not enforcing the comfort letter, or we're not going to enforce the judgment because it's inimical or it's adverse to Chinese public interests? And the investors are going to say, well, wait a second, you're taking your orders from, the ruling party. And that is something that also has to be taken into account. It certainly does not mean that the courts are not fair, but it raises the question of it. And it clearly, again, perceptions do not inherently translate into bad faith. China is a capitalist country. They have an interest in internationalizing the yuan, opening up its own capital markets. President Xi personally announced plans for the recently opened Beijing Stock Exchange. So they are, certainly incentivized to have fair courts and fair decisions. It does not mean that necessarily that the courts would be unfair to the overseas investors, but it is something that has to be taken into account because it does have a different economic political governance model than most Western countries, or virtually all Western countries. And this implicates the idea of good faith, bailouts. Should China continue to bail out countries, or should there be a moral hazard? It's kicking the can down the road. The vice premier has purportedly said, it was reported in Bloomberg, that this is not going to continue. This is going to come to an end. It's kind of like having if you think about it, anyone who owns an apartment or a property, let's say you have a tenant. Let me give you an example. Let's say 3 years ago, the tenant was late 2 months, and they paid it. Okay, very good. Then the following year, they're late 3 months. And again, they pay it back, all is done. Okay, and they're on time. Then this year, they're late by 4 months, and you say to them, you know what, that's it. I'm having a problem. I'm giving you 30 days to get out. And they go to court and they say, but my landlord, he allowed me to do this for the last 2 or 3 years. I was late for 2 months. I was late for 3 months. So now I'm late for 4 months. And the landlord says, well, you know what? I let them get away with it, but you know what? It's too much now and it's damaging me. So is the landlord right in taking action now? Or is the tenant fairly relying upon it's kind of like a moral hazard issue? It's interesting. I don't have an answer. Anyway, I think we're at the last 2 slides. But from the perspective of the creditor, the refusal to comport with past practice might demonstrate a lack of good faith. From China's viewpoint, maybe they're going to say, listen, we need to stop the cash out, and we're going to put an end to this, and there's no more Mr. Nice Guy, and that's it. And we're not, the comfort letter is not a binding contract, and too bad. You can take losses, and that's it. And this is the last slide before the thank you slide. I can show you, thank you. But this is the very last slide. Specific factors that might impact on good faith and comfort letters. 1, China seeks to ultimately serve as an alternative or a replacement to the U.S.-centric financial order. They risk reputational harm if they screw over foreign investors. So that kind of militates towards honoring letters. At the same token, in China, economic interests serve political interests. And if honoring the letter threatens political interests, there will be a perception of a lack of Western-style judicial independence. For those of you, and I'm sure Gotti is familiar with, recalls the Rawls case in which CFIUS had basically ordered an unwind of a transaction, and the Chinese investor went to court and ultimately prevailed at the appeals court, because the appeals court, if I recall properly, said there was a lack of due process. And the Chinese, it was in the press, the Chinese were shocked. They were impressed. They said, wow, can you imagine that in the United States you can actually have a court order, a court order against the American government? It was kind of like, wow, it's unimaginable. So, I don't know, maybe in China, it's a double-edged sword there. They want to, reputational harm they want to avoid, but on the other hand, political interests dominate. 3, hunt for yield and willingness to accept the risk. People are looking for yield. People are more willing to take a risk. And does that mean that the good faith issue is more complicated? Absolutely, because you can have investors who know that the company is in trouble. They're offering high interest rates, and there's a big opportunity, there's a big chance that they will default, but it's worth the risk because we're going to get our money back. The government will bail them out. They're too big to fail. I mean, is that good faith reliance? I don't know. Interesting. And last but not least, is there a more reasonable reliance on the letter when the issuer is a state-backed entity as opposed to a private entity? Is there more muscle involved? Does that play a part in it? Anyway, I think I went a couple of minutes more than I should have. I apologize, but thank you. Xie for those from China. And that is it from me.
Thanks very much, Joel. It was fascinating and certainly engaging, partly because you take us onto a political system that most of us don't know much about. And I have 3 quick questions about it, and following your replies, we are going to open the session for Q&As. So one question is whether the terminology of human security, which is broader than national security, may affect legal debates regarding transactions with China. My second question is, because most often the terminology is a terminology of national security, and my question is whether the terminology of emergencies has been used in legal debates regarding foreign transactions with China. And my third question, you may wish to elaborate to what degree the corona pandemic has affected legal debates regarding transactions with China.
Wow. Okay, those are great questions. Thank you so much for these questions. The first one I didn't hear the beginning, but let me, and I guess I should have written them down. I didn't realize there were going to be 3 of them. But let me start with the last one because I remember it. Okay, I'm not aware personally of the pandemic influencing the debate with respect to contracts China. I am aware, and it's in the article, I don't remember the name of the case, there was a case in India where, and it's very fascinating, where somebody said that we can rely upon the comfort letter, and the comfort letter issuer basically said that this is an emergency, and then COVID-19 basically takes away any effect, and the court actually sided with the letter issuer and said, you know what, this really is a changed circumstance. Again, it borders into material, as you know, material changes, and this, in securities litigation, that's a biggie. You can write a book on that. But essentially, the court, I think, took into account that the comfort letter surely would not be enforceable, not only that it's not enforceable as a contract, but that the pandemic really does change things. But as to your specific question, when it comes to China, I personally, doesn't mean that it doesn't exist. I'm personally not aware of it. I'm sorry, what was your second question? And then we'll go in reverse to your first.
I need to unmute myself. Whether the denotation of emergencies is being used because the pandemic is about emergency, not necessarily national security, or is it completely exchangeable, and courts don't really differentiate between an emergency and national security crisis?
Well, that's fascinating, and I think you'll remember in the Argentinian crisis, moving away from health for the minute, the question was, does an economic crisis justify the invocation of the essential security exception? Just to refresh people's recollections very briefly, it's a great point, is that there was a bilateral investment treaty between the United States and Argentina. And there was an economic crisis. There seems to be an economic crisis there every number of years. But there was an economic crisis, and U.S. investors lost their money because of some decisions, some governmental decisions, and they filed claims pursuant to the U.S.-Argentine BIT. And most of the courts most of the arbitration panels held that mere economic crisis or mere economic dislocation really is not sufficient, although there was language, and particularly in one case, and again, it's in the article, and I think I actually referenced it in the presentation, where if it would disturb public order, it would lead to it. So my answer is that maybe, and I don't know, it hasn't really been addressed. What's fascinating is if a health crisis would lead to a breakdown in public order, would that justify invocation of the essential security exception? I would imagine that more enlightened arbitrators would say that it might very well. Again, there's a slippery slope, but breaking down public order and having people at each other's throats, what if there's a vaccine and there's a supply of 100,000 and 2 million people want to get to those vaccines? They start killing each other over it, and the government says, well, you know what, we're going to take these measures in order to buy more vaccines, and we're going to clamp down on foreign exchange transactions. And foreign companies say, well, wait a second, you can't do this. You can't all of a sudden double the taxation on us. And they say, well, there's a public emergency. We have our own citizens are going to kill each other. We need the money to buy more supplies. So I could see it.
Okay.
And what was your...
Now, by the way, in Israeli law, which is by basic law of the government, stipulation 39, if you do have a danger to the supply of basic services, the government is statutorily authorized to issue emergency legislation. Okay, so let's open it to Q&A from our audience. Ida, are you also taking questions from the Facebook audience? Or?
So far we don't have any, but if there will be, we'll I will be reading them.
Okay. First of all, a proper disclosure from my experience, professional experience in debt issuance in the international market, not with China, but with the United States and Europe. I'm a little bit amazed from this discussion dealing with conflict letters, because we know that there are other instruments, legal instruments, like floating charge, fixed charge, letter of intent, and so forth. By the way, conflict letter in an issuance is given by the auditor to the underwriter. I have never seen any investor that, I don't know about China, as I said before, that asked for a conflict letter because of its, liquid status. So to me, it seems that the American investors, with regard to the interrelations with China, demonstrated greediness. Because today we have we have Fitch, we have S&P, we have Moody's, the rating agencies, international agencies, and whenever you are issuing bonds, you have the rating of the bond. Now, if the bond is rated investor grade, so it's okay, but if it's rated, triple C and so forth, I cannot imagine any rational investor that will ask in such an issuance to have comfort letter. Now, if this issue is, the issue, I don't think that we have to blame anyone but the investors, because they have acted irresponsible, especially with the state that is a non-democratic state, non-transparent as China, and everything can be translated immediately to national security. So the greediness and the high yield that they are asking can, at the end of the day, be, a default, and the only thing that they can do is blame themselves and nothing more. I think that in addition to that, I think that the United States should, in a way, it's a way of paternalism, should in a way regulate or enact such requirements that will not permit investors to enter into issuances of bonds based on conflict letters. This is my remark. Thank you.
Wow, that's very interesting. Let me just address the last part first. Would you advocate, and these are great points, would you advocate that they legislate that investors can buy debt backed only by comfort letters, only with respect to China, or are you talking about like generally at any point, any country?
In general.
Okay, interesting. I don't know. That's, you're absolutely correct that for fiduciaries that have a duty to invest only in the highest levels of debt because of their enhanced fiduciary duties, if they do invest in a debt that's backed by a comfort letter, it does kind of sound egregious, irrespective of whether it's China, irrespective of whether it's the U.S. issue or whatever it is. And yes, I'm very fully aware of comfort letters, as you mentioned, in terms of the SEC regulations. But in China, it's different, as you mentioned. We're dealing with different. Your point, the first point that you made, which you made, eloquent points. There is a point to what you're saying, the rebuttal, and I'm not saying I disagree with you. I'm not saying I agree with one position or another, but you can see that many, many US companies and individuals are rushing to invest in China. Whether they're foolish or not is beside the point. You've got Ray Dalio, who's the head of Bridgewater, which is the world's largest fund, and he's going gaga over China, and he's come under a lot of criticism, as you know. I'm sure I could see you're interested in this area, so you know about investments and economics. But he's come under intense criticism because he has actually made remarks that are actually quite favorable to the party and to China's system. And people say that he is basically selling out his principles for profit. Whether that's true or not, I don't know. But I think this is what I want to get to, is that why do people, and you ask, why do people invest in Chinese offshore debt? Well, that are backed only by comfort letters, because they see China as a profitable place. They're presuming there's state-backed guarantees, which comes to the moral hazard that I discussed, and they see opportunity. I mean, why is Mr. Musk going gaga over China? Because it's a huge opportunity. People say that he shouldn't do it because they're going to take his technology. I mean, people have been claiming that the United States companies have been, ripped off because they've got to do the technology transfer. But that's their business, in a sense. And, I think that's obviously driving the national security issue, as the United States is kind of trying to decouple, in a sense, and is basically telling the U.S. companies, like in Xinjiang, don't invest in Xinjiang, stay away from Xinjiang on the human rights issue. So I don't know. I think people will make their decisions. I think that the opportunity in a low interest rate environment, when you've got ZERP policies in the Western world and you've got Chinese debt that's out there, it's very luring. There are people who are buying Evergrande debt as we speak, even though it's selling for pennies on the dollar, because they're presuming the Chinese government is going to bail them out and they're going to make a huge profit. Maybe they're right. Maybe they're wrong. Just like Warren Buffett, he hates Bitcoin, right? He's like, anyone who buys Bitcoin is a fool. Okay, I mean, well, it's 50,000. It's about 50,000 a coin. If it goes to $250,000, I mean, Jamie Dimon made a mistake. I mean, Jamie Dimon, he basically said, what was it, 3 years ago, that it's a sucker's bet. I mean, maybe eventually it will be, but at this point, anyone who listened to Jamie Dimon 3 or 4 years ago made a bad mistake. They could have bought Bitcoin for a couple of thousand, and they would have, the return, it was tremendous. So people are taking the risk with China. I hear what you're saying, and I guess that's a risk that people seem to be willing to take. Don't know. But that's a fascinating. Actually, the second point is actually fascinating about basically prohibiting investments. I guess you'd have to. I guess you'd have to basically make it for fiduciary. Even if it has a AAA rating, if it's only backed by a comfort letter, that it should be prohibited investment. That's fascinating. It's a fascinating question. You could write an article on that.
More questions, maybe from our postdoc students, maybe Asaf or Adele or. So, Jera, I would like to ask you whether you describe and analyze a certain dynamic between China and the United States. Do you identify the same kind of dynamic between another democracy and an authoritarian system, or a developing country and a developed country? Because you mentioned previously the United States and Argentina.
I think it's an interest. I don't know if you've ever been to China. I've been to China many times, and it's actually it's very different than the common perception that people outside of China have. It actually is a very capitalist country. There's more communists in California than there are in China. And people kind of think that it's a militarized state. Actually, people have a very, from what I saw, and I was only in the big cities, and obviously I'm intermingling with a certain demographic group, but I love to walk, and I walked around, I saw clean parks. There are cameras everywhere. You are being surveilled all the time. But you know what? You go to a park, you could eat off the playground. People don't litter. Why? They probably don't want to get a fine. It'll be taken out of their WeChat accounts immediately. So, from a political perspective, you cannot openly criticize the CCP, and you cannot, advocate for any sort of systemic change. But you are not, in some sort of open air, prison. I mean, people do debate things, people do discuss politics, people do discuss economics. There is, other than criticizing the political system, it's not really so different than other countries. I mean, people go to work, they make their money, they invest, they go to movies, the malls are packed. I think a lot of people have a very certain untoward perception of life in China, and it's kind of very eye-opening when you're there, and you see things are actually very different than what is properly understood as life in China. It's, yes, there are cameras. Other than cameras and surveillance and the inability to critique the governance system, it's really not very different. And I'll tell you something else. I'm not so sure that their governance system is not going to be slowly coming to other Western countries. I think that facial recognition is going to come to many Western countries. I think that the system of governance that they have slowly is kind of being incorporated. I mean, even state-centric governance, if you look at the United States, they are, subsidies for companies to do innovation, the Innovation Act. Trump, before he left office, he actually was, I forgot who it was, I think it was, wasn't Pompeo, it might have been the Attorney General Barr, basically was floating the idea of the United States government buying Nokia and Ericsson, make them state-owned enterprises to compete with Huawei. That's basically the United States incorporating principles of state-centric capitalism. I think when Biden was voted, when he was elected, before he actually took the oath, I think it was the CEO of Intel, he basically said, in order to compete with China, we need state subsidies. We need the government, the federal government, to partner with private companies. That sounds awfully similar to the system that they have in China. And again, it might be because it is seen as successful. It might be because it is necessary to compete with. But I see the Chinese system being incorporated to certain degrees by Western countries. And I think particularly in terms of emerging technology and surveillance, I think that's on the way. I think it's a question of time. Maybe I'm wrong, but I think it's coming.
Okay. Thanks very much, Joel. Questions, comments? Zachariah, are you satisfied with, or would you like to have more questions about the issue?
I think that the only thing that I would add is that there is a dilemma between intervening in the capital flow, in the flow of capital, or in the free market on the one hand, and the responsibility or irresponsibility of each and every investor. Today, there are means, as I stated before, there are means to alleviate the uncertainty as regards investment by the rating agencies, by other legal instruments like floating charge or fixed charge or letter of intent. And the very problem regarding comfort letter, I think, lies on the irresponsibility of the investors that are so greedy, because they are, on the one hand, they are driving and wanting high yield. On the other hand, high yield doesn't go with low risk. It goes together. It's a symmetry. High yield with high risk. And if you don't require other instruments than comfort letter, the only thing is blame yourself. Blame yourself. Now, if the magnitude of the problem in the United States is such that it becomes a problem of national security, so from that point, I think that the SEC or other agencies in the American system should negate and should avoid transactions based on this instrument called comfort letter. This is my comment.
Okay. So, by the way, I think, Zachariah, the question is whether the Chinese government would allow transactions to be made without comfort letters. So I'm not sure about that. I'm not sure that investors in China do enjoy other alternatives.
Okay, so the answer is that the reason why comfort letters are used is because under Chinese law, the onshore entities cannot explicitly guarantee, they are forbidden to guarantee offshore dollar debt. And that's why comfort letters are utilized in that situation. Again, Zachariah has a great point about individual responsibility. I think his argument is, and there's something to it, is that if you are willing to take that risk, you know that there is no explicit guarantee, then the bottom line is you took the risk. If you lose your money, ultimately it's your fault. You knew that there is no express guarantee. And, whether, it's their choice. If they he describes it as greed, maybe people are just driven by the fact that they want more money or higher interest. It's their responsibility. And of course, that goes to the sophistication. Can we expect the young or the relatively unsophisticated investors to understand the difference? That's again, that's why I divide in the presentation. I think there might be a difference in terms of good faith between a sophisticated investor such as Goldman Sachs and Mr. Cohen or Mrs. Cohen from Hadera, the popular simile. So I think there might be a difference.
Yeah, I think that, Joel, in your lecture, you have alluded to a tension between capitalism and authoritarian system, and how that kind of a tension is being mitigated through manipulation in the terminology of national security. So this is a very important tension that we often mix between democracy and capitalism, but in fact China would be a rather capitalist society, a capitalist state in an authoritarian setting, which invites all kind of complexities. If not, I think this is a good opportunity to thank you very much, Advocate Joel Slawotsky, from a very intriguing, engaging lecture. I think that we studied a lot because often we don't talk as much, especially not in our faculties, about the Chinese backdrop and it was a very interesting conversation. And hopefully we shall see you time and again as a guest in Minerva. So thanks for coming.
It's a pleasure. It was enjoying. And you, as you've written, politics, you really can't separate politics out of the law, right?
Exactly. Thanks very much for coming. Have a nice day, everybody. And thanks to Ida and Michal for organizing this event.
Yes. Michal is great. Thank you, Michal. Thank you.
Very much.
Thank you very much.